considering what we are aiming to do, just to, spread the word around these practice areas and, spreading know-how regarding these. And there's no better, a person we could think from the Indian jurisdiction to, have currently. Before we delve into further discussions with Rishab, a short, introduction to Rishab. Rishab has been a triple qualified English barrister. He's English qualified. He's Indian. He's an Indian advocate, also qualified with the New York Bar, with more than 15 years of experience in handling complex international disputes. He's widely recognized as one of the leading arbitration lawyers globally, and he's recently, I believe, been ranked as a global leader in the field of arbitration by GAR's recent ranking on the 45 under 45 list, I believe. He started his career at Allen & Overy in the London office. I then believe he moved on to DeVois and Plimpton in the New York office, and then subsequently he was a partner at Sharda Ramarchand Mangaldas, where he led the firm's arbitration practice in Mumbai. He has represented several clients in high-stake commercial disputes under various institutional rules, and he's represented states and investors alike in investor-state arbitrations. The regions he normally aligns with are London, Singapore, Hong Kong, New York, and he's dealt in with several legal regimes such as the common law, civil law, and Islamic laws. Likely, he has represented in talking about purely from the perspective of investment treaty arbitration. He's represented clients from Europe, Africa, Asia under the ICSID as well as the UNCITRAL rules, and. This is just as a professional experience. Academically, why it is so, it's so always so interesting to talk to Rishab is because of his deep affinity towards academia. He holds a TEFL in international investment law from Oxford University, where he was a Rhodes Scholar. He started his educational journey with a Bachelor of Arts in Mathematics from then Stephens College. And he continues to teach in universities across the world. I can go on, but just to give a brief background, as brief as it can be, into Rishab's, what Rishab brings to the table professionally and academically. Welcome, Rishab. Thank you for joining us today.
Thanks, Anupam. That was brief, though. It was a fairly lengthy introduction, but thank you very much for reading all of that. And hi, Paris. Good to see you as well.
So my first question to you would be, where did your inception to studying math come about at the St. Stephen's College, and since that, what led to the transition in law?
It's obviously going back a lot of time because I was in Stevens doing maths honors from 2001 to 2004. When I don't come from a legal background at all, in the sense that my father runs a small business in Delhi, my mother is a homemaker. So there's not really any background in terms of law within my family. So there was no reason why I would have chosen to study law immediately coming out of school. When we were in school, at least in Delhi, at that point of time, either you applied for engineering or you looked for a liberal arts college. And there was no other liberal arts college in Delhi that was better known than Stevens, at least at that point of time. So it was just a natural choice to gravitate towards Stevens. I wanted to do economic honors. I couldn't get into economics. So maths was the second best choice. It was as simple as that. Once I was doing maths, it was very evident to me after, I think, my first year itself, that it's not something I would like to pursue any further, because I found maths to be too abstract. I thought the kind of things that we were dealing with, vector spaces, metric spaces, etc., they were just too abstract for my liking. So I was looking for something which was more real, something which was actually attached more to the real world problems that people face. And Delhi law faculty, which was just opposite to St. Stephen's geographically. There were lots of people I got to know there over time. Stevens was also a very charged college. There was a lot of stuff happening globally, nationally, that wouldn't necessarily get discussed in Stevens, not necessarily in classrooms, but outside. And that all of that meant that I started slowly gravitating towards law. And by the time I came to my third year in college, it was very evident to me that I wanted to study law. It was just a question of whether I study it in India, or if I get some scholarships, then I'd probably step outside of India. But I think the decision to study law had been made, at least in my mind, by the time I reached the third year.
Why I find this fascinating for your journey from mathematics to law is primarily because in law school, I myself studied chemistry. Like, I did not have the subjects like sociology or economics. I studied organic chemistry as my honors, so which had no connection with the second period I had, which was possibly legal methods or contracts. So yeah, quite fascinating.
And when Rishab was talking about this mathematics chair, I was also thinking that a lot of people who would be listening to this conversation later on would take a lot of heart, the law students, from his journey, for the simple reason that, Rishab did not come from a legal background, and he's made it where he is today in a very short span of time. So I think that's also very inspiring. That's going to be very inspiring for a lot of young viewers and listeners when this episode airs.
Yeah. No, so I'll just add a couple of things to that, because, obviously all of us are a product of whatever sort of upbringing and, experiences we've had. And many of these things just happen by chance, right? They're not fully by design. So when you're sort of doing something 20 years ago in your life, you're not thinking that that particular thing would lead you to something very specific later on in your life. But just two things from what you were saying. You, Anubhav, said chemistry, right? That you sort of did chemistry earlier.
Yeah.
Obviously, when I shifted from maths to law, I never had any desire or plan that my mathematics education would be of any assistance in my legal career. Those were two totally different things in my mind. But today, from where I am, maths has been of a great assistance to me, because a lot of the work I do today involves dealing with quantum experts, for example, in arbitrations. It involves dealing with numbers in some shape or form, because I mostly do only commercial disputes, and all commercial disputes are about ultimately money and damages, right? That's all it's about.
Absolutely.
Most lawyers would shy away from it, both in the terms of their written advocacy as well as in terms of cross-examining experts on issues which are complex and involves numbers. I absolutely love it. And sort of that, in some respects sets you apart, in other respects makes you more sort of fulsome when it comes to actually dealing with the entirety of the dispute. So, I suspect that might be true for you as well in the context of having done chemistry and therefore being more open to scientific ideas, being more open to mathematical propositions in the context of the disputes you do.
Yeah.
And Paris, the point that you made about, not coming from legal background and perhaps that being of some inspiration to others, that I don't know whether it will be of inspiration or not. But I'll tell you one thing where it's relevant. Because I never came from that background, it obviously meant that I had to charter my own course, right? And I had to charter a course which I thought would require least assistance from that kind of a background. And that necessarily meant that I always sort of gravitated towards something which was less courts-oriented and more international arbitration-oriented, because that to me is far more meritocratic than our court system. And I don't think anyone would dispute that statement. So again, what happens is that depending on where you come from, you choose a certain background, which may ultimately work your disadvantage as well, right? There'll be lots of very, very good lawyers who are in the court system, not doing something which perhaps is closer to international arbitration because they thought it was easier, given the background they came from, to just stick to what their father, their sort of other people in their sort of earlier generations might have been doing. So, it works both ways, I think, and it can actually work really to your advantage because you're not sort of stuck to some particular choices that people in, your family might have made earlier in the past, yeah.
So certainly, I think that's a very good point, I mean, you're coming without any sort of baggage or luggage, and I think in a way that certainly gives you much more freedom in terms of choosing a course for yourself. That's certainly a good point.
And it's very interesting that you say that because about an institutional setup which is going to courts as opposed to a meritocratic society. When, for example, 6.5 years back when we started Triumvir Law, and we started out of Bangalore because we realized that, we did the numbers that, there were about, close to $4 billion of investment coming in to Bangalore as a state. And there was the age group receiving this money was between the age group of, 23 to 40. And they seemingly wanted to interact with younger lawyers and this culture existed in this city. And I thought that, this is way more permeable as a market one, as a city, and also you to be accepted as a young law firm, which is purely a meritocratic society, because if you service well, you exist. If you do not, and then you do not, right? And as opposed to going to court where, you're getting a brief or you're getting matters which are recognizable, seemingly might be connected to, a pedigree you might be coming from, so on and so forth. So I've never thought of it this way, but that's a very interesting point. And that's what we do. Our work is purely private equity, venture capital, and international arbitrations. So there's two very distinct ways.
Yeah. Correct. No, sorry to interrupt, but I think you're absolutely right. That if you look at sort of the legal market generally, most of the transactional work that you do, your clients wouldn't care what your surname might be. Your clients wouldn't care where you come from. Of course, pedigree in terms of your legal education may matter, but that's a very different point. That may or may not make you a good or bad lawyer. Equally, that would be true for international arbitration as well. I've always said this, that, it's bizarre that people like us at sort of a relatively younger age in the profession would feel far, far more comfortable taking on the opposite side, very well-established practitioners in international arbitrations where the arbitrators are, your foreign nationals, etc., as opposed to taking them on in your home turf, for example, in the Bombay High Court or the Delhi High Court. Because the point is that ultimately, unlike a judge in the Indian context who sees those senior advocates, who see those very well-established practitioners in the Indian setup day in and day out, and therefore has a certain sense of, expectation or a bias that may exist. There's no such thing in international arbitration, because to a foreign arbitrator, Mr. X and Mrs. Y are the same, right? Like they know neither, right? And therefore, it all comes down to your preparation. It all comes down to the merits of the case. It all comes down to the presentation of the case, which unfortunately need not always be the case in courts, because there are certain underlying biases and underlying expectations that the judge might have. But yeah, that's a larger point. We can keep talking about that.
Yeah, we can go on and about this. But then just coming back and circling back our conversation, how was the transition from St. Stephen's to London School of Economics in terms of studying law? Was it pre-decided? Was it well thought out? And do you think that it really added value to your legal career in terms of studying law? Now you practice seemingly a lot in Bombay as well, right? So was there any difference as such?
Yeah. So see, again, it wasn't as well planned as it might appear looking backwards. At the time, as I said, I had decided by the time I reached my third year in college that I wanted to study law. I had sort of, in my mind, decided that I would either study in India, and the natural choice was Delhi Law Faculty in Delhi, or I would step outside provided I can get a scholarship. I applied for the Rhodes Scholarship. That was the first scholarship I applied for. I made it to the final round, but I didn't get the scholarship. And after that, I'd sort of decided that, look, the only backup option here would be to go to Delhi Law Faculty. I still remember just a few days after I got rejected in the final round of Rhodes, a friend of mine showed me a small advertisement that had come in the Hindustan Times saying that HSBC has just launched a fresh scholarship where they're going to select 2 students on an annual basis and fund their education abroad. And it was an uncapped scholarship. You could choose the university, etc. By then, I had got admission in a couple of schools, so I applied. for the HSBC scholarship. I'd never heard of it. It was the first year that they had actually introduced the scholarship. And, went through multiple rounds. The final round was here in Bombay. I still remember Ramchandra Guha, the famous historian, was the head of the panel. And, much to my own surprise, I got the scholarship. And, the thing that really distinguished HSBC from Rhodes at the time was that the Rhodes panel found it very hard to digest the idea that I was shifting from maths to law, because at the time they used to select 6 students from India. And that year when I had applied, there were 2 NLS students, Tarunab, and I can't remember the name of the other person, who was selected in the final round. And they found the idea, and there were lots of lawyers on the panel. Manmohan Singh was the head of the panel at the time. This is just before he became the panel.
Fascinating.
And they all found the idea that, you're a maths student shifting to law, sort of quite difficult to digest. But Ramchandra Guha, on the other hand, and I give him a lot of credit for that, and, the rest of the panel loved it. They thought, this is great. I mean, the fact that you're willing to take the risk, the fact that you don't want to do an MBA or whatever, your colleagues might be doing. They thought that was really cool. So they funded my scholarship at HSBC, which meant the decision became much easier. I went to London. I was there it was supposed to be a 3-year course. But at the end of the second year, I got selected on this dual degree program that LCIA had just launched with Columbia, where you join the JD class in Columbia, New York, in the second year. Again, that's interesting. I look back at it. Columbia was thrice as expensive as LSE. So when I got selected for that, I had to obviously go back to HSBC and say that, look, I got selected for this program, but this is going to increase your expense each year by 3 times, plus a 3-year scholarship would become a 4-year scholarship because I would spend another year studying. And I almost went there thinking that they'll just say, obviously this is not going to work out. And therefore, I had made a conditional acceptance for that offer to go to Columbia, because I knew that it'd be a difficult conversation with HSBC. I was actually just a 5-minute conversation. They're like, yes, of course, why would we not fund it? I mean, it's great to getting this opportunity to do it. We would fund it. And the next thing, they were asking me questions like, oh, do you know how much stipend you would need in New York? Do you know how cold New York is? How much do you need money for your warm clothes and stuff like that? It was amazing. So yeah, that's how things transpired, basically. That's how I ended up in London and then in New York.
That sounds, opportunities come your way when you're least expecting it. And, that's the reality of things. And to be very honest with you, I had no idea what international arbitration was. And I was in my second year as a law student, and I did not want to be a commercial lawyer. I just wanted to be a toxicologist. Like, I was studying, I was studying blood spatter, microbiology with law, because you need that. And Professor Martin Hunter had come to teach in our university. And just before going to his lecture, I did some scrambling and reading about the UNCITRAL and what the New York Convention was. And the first thing he asked was, does anybody know what the UNCITRAL is called otherwise? And I just raised my hand and said, New York Convention. And then he was like, okay, yeah, you. Okay, cool. And then we just kept talking, and I was so enthralled by, just speaking to him. He then asked me to join him for lunch the next day, and he just told me that, we'll keep talking till the next year, and there's a possibility that the year after I might call you down to my chambers. So that one year, he just asked me pictures, like, of me in a moot court competition, of me in a vacation, me partying, just to see if I do fit in social settings, and my CV and my internships and so on and so forth later on. And then the next year when he came back, he told me that, do you want to come and spend 6 months with us in London? So it was a dual course, not a course per se. I would spend time with him at Essex Court Chambers and also get to time spend at the international arbitration practice at Freshfields. And for a young boy, studying law with nothing to do with international arbitration, thrown in the middle of it in, legal London, then you see the sky is the limit, and that inspires you to do. And everything was paid for. So, and that, completely changed the trajectory of my career from thinking to be a toxicologist in crime scenes to hear today. What serendipity brings is absolutely astonishing. So yeah.
Yeah, no, you're right. And the reality is that as we grow older in our lives, hopefully we are also making similar positive changes in someone else's life, right?
Absolutely.
And that perhaps is the most important thing after a point. We've all reached a stage in our respective careers where financially we're very secure, professionally we're very secure. Of course, there are many more things to achieve, but
absolutely.
But in terms of basic requirements, they're all met. And yes, therefore, having someone else speak about sort of impacts that we may have had on their life, much the way Martin Hunter had an impact on your professional life. I think that's probably the most important thing going forward for each one of us.
Absolutely.
It also sort of re-emphasizes, I think we hear this a lot, but a lot of people sort of tend to forget this. Opportunities can come knocking at any point, sometimes when you least expect them out of nowhere. And B, I think, always go and have a conversation, always ask that question, have that asked. The worst that can happen is no, but the best thing that can happen to you is you will get what you want, like Rishab happened with you. You when they expected that, HSBC would say no. But I mean, in 5 minutes, HSBC sort of set you on path that you were destined to be. So, I mean, these things work in mysterious ways. And Rishab, it took you across the world. It took you to UK, took you to US, back to India, and now you're practicing all over the world in different jurisdictions. So, I mean, how have the experience been in terms of working in different jurisdictions, different legal systems, and when today you look back at it, how would you say that these experiences of being in different countries and cultures have shaped your journey as a lawyer and your approach towards arbitration in particular?
Yeah. No, that's it's a long answer to give, I suspect, but I'll keep it as short as possible. See, my first job was in New York. I started at a law firm called Gabby Boyce & Clinton, which at the time, when I graduated from law school in the US, was considered to be one of the best for international arbitration.
Absolutely.
I had done my summer internship there, and during that summer internship, I'd done one small investment treaty case against an African country. I'd never studied investor state law in school. I just thought it was fascinating. I wanted to do public international law, but I was always told that there's no money in public international law. And here I was sort of getting paid really well during my internship days, getting to do work that I thought was super exciting. So that to me at the time was great, that I'm getting to work at a top law firm, getting to do the kind of work I wanted to do. But I was always very sure also that ultimately at some point I would want to return to India. And that's why doing anything which was very specific to the US jurisdiction, such as federal court litigation, state litigation, etc., that wasn't really my cup of tea, because I thought that that's not the skill set I want to develop. I worked in New York for a couple of years, but thereafter I got my Rhodes Scholarship. And that basically meant that I had to move to England for my sort of research studies. I basically chose to do a PhD at Oxford. I switched law firms. I initially did obviously my sort of full residency at Oxford, but once the residency requirements were met, I was doing my PhD while working in London, and I switched law firms. I joined Allen & Overy. And that's when I focused almost exclusively on international arbitration. And I was there for 4 years. But again, the idea was that, the moment I feel that my other commitments are met and I'm ready to move back to India, I would like to move back. So finally, in 2016, I moved back to India. At the time, obviously, it was a big decision. I'd been abroad for nearly 11 years, studying and working. There was no need for me to move back. I was doing well in my professional career. I could have stayed on. But I just thought that, if I don't do it then, I might find it harder to do it later. Also, the split at AMSS had happened just a year before. Sam existed as a new law firm. I knew some of the people there. They said that this was a good opportunity to come back and probably set something of your own in Bombay. It was a young law firm. There was a lot of autonomy. So I joined SAM in 2016 with a very clear mandate to try and develop the international arbitration practice in Bombay and in the firm generally. And then I was there for 6 years, and it was fantastic. I had a lot of autonomy. I built an amazing team. We did some really, really good work, both sort of in terms of international arbitrations for Indian clients, but more importantly, my underlying thesis always was that there's no reason why in India we shouldn't be doing work for foreign clients, i.e. doing international arbitration work, which has nothing whatsoever to do with India. Because in much the same way as a foreign law firm can be doing an Indian arbitration with them, nothing to do with India. The same should hold true in the reverse direction as well. And we did that kind of work as well. And I continue to do it, but now obviously in a different capacity. But broadly speaking, that's the journey. It started in New York professionally. I moved to London and then moved back to India. But moving back to India was always sort of a large part of what I thought would be my career. And even today, having sort of taken this decision to be on the counsel side, be a barrister. Obviously, my chambers are in London. They have an annex in Singapore. I maintain chambers with them in both jurisdictions. I could be living in either of those jurisdictions. But for me, this was a very important part of my decision-making that I would not leave India unless I'm sort of compelled to do that for some reason. I love being in India. I think the work we can do in India is fantastic. Most of the juniors I work with, I personally think are superior to the juniors I work with in other jurisdictions. Indian clients can be annoying, but clients can be annoying in any jurisdiction. Indian courts are annoying, far more annoying than any other jurisdiction. But, my practice doesn't require me to go to courts that often. And when I do, I enjoy it because unlike in most other jurisdictions, I get to do both. I get to appear in courts a little bit, but focus mostly on arbitration. But all in all, I often maintain this, and we can come back to this theme, that we in India right now are living in the golden times. It's the best time to be in India. The opportunities are immense. The work experience you can get in India is fantastic. There's a lot of money to be made, and that's an important aspect of, your sort of professional aspirations. But more important than anything else, barring the United States, every other country believes, at least the major countries that I have lived in and worked with, there's a strong sense that the best was behind them and the future would probably be not as good as the past. Whereas India is the opposite, right? Like every person you meet is very optimistic about the future, believes that there are better times to come. And that makes a huge difference in your general approach to life, So I have, very often people ask me why not move back to England or to New York or whatever. But I have just enjoyed every part of being in India. And I intend to continue doing that.
No, I agree with you completely about, being in India and, but there's one thing that you possibly stressed on is giving back, possibly the impression that Professor Hunter had on me and some of your mentors had on you. How do you look at giving back to the, to students or empowering them and so on and so forth, fresh graduates who are, joining the bar and so on and so forth?
Yeah, I mean, it's an important part, and I struggled with this on my own as well because, there's no clear path to it. And obviously, you need to have proper time for it as well. And most of us don't. And as you grow older, family commitments, I have a son now, I have to spend time with him. That wasn't the case earlier. When you're dating girls, it's a different point. I have a wife, I have to be with her and so on and so forth. Yeah. But, the few things that I feel I have tried to do, not always successfully. One, of course, teach. Initially, I used to try and do guest lecturing outside of India, but increasingly, I only do it in India because I feel the need is greater here. Yeah. Second is, of course, do as much training sessions as possible. So I do quite a bit of that, both with here in Bombay with the Bar Association, but otherwise, just doing training sessions with institutions and so on and so forth. Again, those won't take you very far because there's only that much you can impart through training sessions and only that much time you can give to it, but whatever little you can. But I think the most important thing I personally feel is just involving more people in the work you do and giving them an opportunity to see through your experience and through your matters, things that they would not otherwise see. We are very, very lucky, and I suspect I am very, very lucky that, by sitting in Mumbai, I'm doing matters which most people in India would not be doing, matters which are totally outside of India, often don't involve Indian law, and so on and so forth. Just the idea that, that can be done, and seeing and letting other people be part of that, I think in itself is a great experience for them and gives them the confidence that this can be done. That it's not necessary for the purposes of doing, let's say, international arbitration that you necessarily have to live outside of India or be working in a foreign law firm. It may be good to go out, get that experience, because unfortunately we still can't give that wholesome experience in India. Very few firms or chambers can do it. But ultimately, to my mind, the most important thing is that talent has to come back to India. That, those of us who do go abroad, study abroad, and especially those of us who, like me, go abroad on taxpayers' money, right? I went on scholarship money or, on someone else's generosity. We got to sort of give back. And I think give back often, different people have a different view of looking at it. But for me, giving back always meant giving back to the society where I got that sort of initial corpus of money and initial education from. And that meant giving it back in this society in India. But yeah, no, I don't have a very concrete answer to it. I still haven't really figured out what that might be. But I think as long as I'm open in what I'm doing, I'm sort of involving more people in it. I'm training those who are working with me, giving them the confidence that they can do similar work going forward. I think that in itself is some contribution to the overall profession in India.
Rishab, I just want to take a couple of steps back because, the theme of this entire podcast series that we are doing is Asian narrative. We are focusing on Asia and how Asia and how India is perceived and India's positioning in terms of international arbitration and international law. And there are two very interesting things that, you have just said. One is obviously one of the ways you try to give back in the communities by including junior lawyers, younger lawyers in your matters, which are out of India. The second thing that you said is one of your ambitions has to be a lawyer who, despite being Indian, is actively working on mandates which does not involve India or Indian parties. So you're representing foreign clients in matters which have nothing to do with Indian law. Now, that is something a lot of people have aspired to do. That is something we at Triumvir Law have been lucky to do as well. We have mandates in other jurisdictions which have nothing to do with Indian law. But having said that, it's still a very, very exclusive club. And more often than not, you also mentioned that we find that, states, companies, parties, they mostly turn to European lawyers or, someone based out of Dubai or someone based out of US. When it comes to such mandates. Now, you have obviously been successful in that aspect, but, how do you see it? Why do you think this is happening, and how can people from Asia, people from India, in particular lawyers, build that practice?
Yeah. See, when you say Asia...
Rishab, before you begin, could you just refocus your camera a bit? Like your face is half in my current screen. Yeah, this... You might need to go a bit left.
I'm using my iPad, but I need to move left. Is it like that?
Yeah, this is perfect. Perfect.
Yeah. Okay, great. No, so I'll just answer what.
Yeah.
So see, Paris, my personal view on that is that, look, first you have to just think of Asia as being quite diverse, right? You have within Asia at least two hubs of excellence now, which is Singapore and Hong Kong. So I don't think you can put professionals who are based in Singapore and Hong Kong in the same category as the rest, because they are now seeing the same opportunities to a large extent that you see in the traditional jurisdictions like London or Geneva or so on and so forth. And that's partly because, the large banks have moved to these places, large private equity houses have moved, and so have large international law firms. And increasingly, at least it's true for Singapore, but also largely true for Hong Kong as well, that, they're seeing a lot of international arbitrations which are seated in that jurisdiction, which have nothing to do with that jurisdiction. So it's not uncommon to see two Indian parties or an Indian party and let's say an Indonesian party doing an arbitration in Singapore. So you keep those two jurisdictions out and then you sort of take the rest. For the rest, I think, Paras, what you're saying is absolutely true, which is that even today, they're mostly seeing domestic stuff, right? Now, coming to India specifically, see, there are a variety of reasons why I think we have traditionally not been able to look outside of the four corners of our country. One is, of course, just pure supply demand, right? India is such a large economy and it's so under-lawyered still in terms of sophisticated commercial lawyers that invariably a typical Indian lawyer doesn't need to look outside of the four corners of India. There's enough work for each one of us within India itself. Yeah. So that obviously means that you don't think about, why getting some work between one foreign company and another foreign company, right? Because you sort of think that, look, there's enough for me in India, which is actually true in the US as well. Most American lawyers don't look outside of the four corners of America because they find enough work locally. Yeah. So I think that's the starting point, that supply demand really dictates this. The second part, of course, is that even if you were to look outside, do you have, for example, the right pedigree, the right experience to actually pitch for that work? Unfortunately, we don't in India to a large extent, right? Because this could be a separate topic, but the quality of legal education is still quite bad, right? Barring a few centers of excellence, generally speaking, the quality of education is bad. Because Indian law firms are not doing international work which doesn't involve India, especially international arbitration work, you're not getting that kind of experience in India. So how would you break that? The only way that gets broken is if people get that experience initially by working abroad, coming back to India, establishing practices, firms, whatever it might be, where they're leveraging their foreign experience and then involving other people who may not have the opportunity to go abroad, but would learn through them. And that's exactly how it's happened anywhere in the world, right? It's not as if everyone working in a certain setup would have the same experience, but at least the leaders within that would have it. And I suspect That's very true for your law firm as well, where, you guys who are leading the firm have that experience. You are then recruiting juniors who don't necessarily have the same experience, but have the willingness to learn and a willingness, and you are able to teach them and you're able to train them. And then together you guys can do things which otherwise would not be possible. So, I suspect the answer must lie somewhere around that. And which is why I think it's absolutely critical that those of us who do get the opportunity to step outside of India and work abroad, get that experience. And obviously each one of us has to make our own choice. But to me, moving back to India was just very important from that perspective as well. That if we don't do that, the vacuum that exists currently would continue to exist forever, right? Because if those of us who are in India and can't pitch for foreign work remain in India, then that doesn't help. And those of us who can, if all of us migrate abroad and never come back, then that also doesn't change.
So while I understand, the quality of education in India is seemingly not up to the mark yet in terms of, facilitating us with the tools to, maybe cater to the global market yet. But do you think as a country which predominantly, practices in English, for you to be permeable to work outside India, becomes a problem because of your lack of knowledge of another language, let's say French or Spanish, in the field that we're restricting ourselves with, let's say international law and arbitration and investment treaty arbitration? Because we have seen that, whenever we go out, to pitch for a matter and so on and so forth, there are, bulks of documents in French, okay? Predominantly, we do not grow up learning French or that's not a, it's not a regular thing in the Indian society yet, learning a third foreign language, right? And I think since I've been apprised of this through my practice, what I tell anybody who's coming through the system is that please learn a third language, that will help you rather than not help you if you're willing to do something in this field. But in your experience, what has this been like? Do you think that matters?
Yeah. So there's a positive and a negative here. I'll tell you what the positive first is, and then we'll discuss the negative. The positive is that, for us, English is effectively like our first language, right?
Absolutely.
And that's huge. That's huge because remember, still a very large proportion of the work in this area is done in English. English continues to be the primary language through which a lot of this work is done. There may be some evidence in a foreign language, but a large proportion of this gets done in English. Add to that the fact that we are intrinsically very comfortable with a common law setup, right? So even if you haven't trained and studied for law in India, you understand how the common law system broadly works, the concept of precedent, the concept of cross-examinations, and so on and so forth.
Yeah.
Now, compare that to someone who may have grown up, taking your example, in France or in Germany. English is not the first language, may not even be the second language. You've grown up in a civil law system where the concept of precedent, applying those precedents to your back pattern, doing cross-examinations, completely alien. Yeah. You suddenly come to international arbitration, which despite historically being somewhat of a mishmash of civil law and common law system, has increasingly gravitated only towards common law system, right?
Absolutely.
Increasingly, especially in investor state arbitrations, you apply prior judgments almost as if they're binding, though we all understand they're not binding. And you every time do cross-examinations, which sort of, don't really happen in civil jurisdictions. So that's the huge advantage that we have in India, which is why you increasingly see that across the world in international arbitration practices of major law firms, Indian trained lawyers are doing exceptionally well because all of this comes very naturally to us. Yeah. And I'll just add one more point, which is why I also think that over time, we can build some global world-beating practices in India because you can get some really, really good talent in India. You take all of these qualities I've said, and then you take the intrinsic qualities of an Indian, not even an Indian lawyer. We're all very hardworking. Generally speaking, we're very, very loyal to our profession. We're very, very loyal to what we do. And add on top of that, there's a general sense that we want to prove ourselves, right? Because we all have come from, in most cases, not from very privileged backgrounds. You take those personality traits, you add to that the fact that we can speak and write English as if it's our first language, and intrinsically common law methods and techniques are very easy for us. And you can build a world-beating team, right? What's left? It's just the experience that's left, nothing else, right? All other ingredients are there. So that, to my mind, are the positives, right? Now, the negative in terms of not having learned another language, you're right. I mean, when I was in Europe, you would often come across people who could speak 4, 5, 6 different languages. I could not write. I would write Hindi and Punjabi, both of which were totally useless from this standpoint. So yes, that's a disadvantage. But I would not overstate that because I think there are ways to overcome it. Of course, if you can't read French, you can have it translated. The cost of translation are going down dramatically with, the rise of AI. Just the other day, someone was showing me this amazing platform they have where you can just put documents and almost like the way OCR happens, the translations are also happening. So I think those downsides over time can be overcome, perhaps not completely. So there'll always be some preference for those who can speak multiple languages. But equally, I don't think we should undermine the inherent advantages we have in India.
Absolutely. But while that is absolutely correct, that, we are more equipped to be, successful than, fail by not knowing a language. But then, when I speak to, let's say students who are doing their masters abroad, so on and so forth, in international dispute settlement and so on and so forth, right? And who want to get that exposure outside by working in a foreign law firm and, work on those, prestigious, dispute setup, the market, the job opportunities are predominantly that are there are overwhelmingly swaying towards individuals who know a language as opposed to trying to not.
Yeah,
So you would see, for example,
correct. Sorry, go
No,
ahead.
I was just, you would see, I mean, even if you are looking at UK, you would see that firms increasingly would prefer someone who speaks Arabic or speaks French or Spanish, or, with the Russian conflict going on, either Russian or Ukrainian. So, I think over the last few years, we have seen this trend where even the English law firms, which is sort of a natural alternative for Indian lawyers. But even most of the law firms are now, when it comes to their international disputes practice, they're increasingly looking for people who can speak these languages. And like Anubhav said, I think there's a lot of concern among master's students who are going out. Because obviously, I mean, it sort of pulls you back I mean, you can still have an amazing CV, you could still be really, really talented, and you still might make it. But it does make it just that bit more difficult.
Correct. No, I think, look, to my mind, it still comes down to supply demand, right? So if there's a lot of supply of young practitioners who want to specialize in this field, and you are, as let's say, law firm partner, looking at 5 different CVs. All 5 of them look fairly good in the sense that they all come from good law schools, have done well in college, and so on and so forth. But one of them has, French language skills, whereas the other 4 don't have, or one of them has some other language skills which the others don't have. Then, of course, you prefer that, right? So if it was that there was so much demand that language skills were just considered to be an additional add-on, and hence perhaps those people would get an in first, but everyone else, there was space for everyone else as well, then I don't think we would be discussing language skills to that extent. But unfortunately, I think the reality here is that there's not enough supply, there's not enough demand for this kind of work, for these kinds of professionals, as compared to the supply that's there. And a lot of that supply is getting created today, I think, by countries like India, right? Because a lot of Indian students, after having finished their degrees, are going abroad to do their masters, or are having practiced in India for a couple of years, are going abroad for their masters, are then applying to foreign law firms, and are finding it that it may not necessarily be that easy, right? So,
yeah.
Look, I think if the question is, should you learn a foreign language? Absolutely, you should. Not just because it might increase your prospects in international arbitration, but it'll make you a better person as well, right? Like if I could read Russian literature, I would love to read it, but I know I can't read it. So yes, it'll make you a better informed person. You'll be able to do better things in life that others can't. And hence you should learn a foreign language. But at my age, can I do it? I know I can't do it. I mean, it just takes so much of my mind space that it's impossible.
Do you know another language?
I don't. I've tried. I tried learning French at one point of time. I tried learning Spanish. I was dating a Russian girl for a very long time. I tried learning Russian. I just failed at each one of them. So, and it's really hard, I think there's something about us growing up in India and not being exposed to any of those European languages. And then suddenly at a fairly advanced stage in your life, I mean, I was probably in my early 20s, right, when I was trying all of this. It's just harder. Whereas, with my son now who's 3, I would love for him to get exposed to these languages because it's that much easier.
Yeah.
Rishab, I think in our 20s, we have all tried and failed. I have for a fact. I tried with German, I tried with French, I failed, and I gave up. I mean, I realized pretty quickly that, I just don't have the mind space for that. But moving away from languages just for a little while ago, we talked about Singapore and Hong Kong, when you spoke about the important role the institutions are playing there, and the important role, the tacit support that you get from the government in these jurisdictions for development of international law. And you identified that as one of the major reasons why, these jurisdictions have come up in Asia as a viable alternative to, say, Geneva or UK. Now, when we talk about India in that context, and we have seen certain developments over the past few months. There's a notification there's a new notification, arbitration is no longer the preferred mode of dispute resolution when it comes to government contracts and any mandate where the government is the party. That is one. Secondly, very recently, the Supreme Court in the curative jurisdiction has set aside an arbitration award. Now, I read a lot of views and takes on that particular decision. One of the opinion was that, because it was an arbitration under Part 1, foreign parties do not have to be concerned because Part 2 is completely different from Part 1 and so on and so forth. But at the end of the day, it does reflect on the regime we are trying to create in India and the way it is developing, right? So how do you look at that? And in that context, then how do we sort of reposition India when it comes to developing a truly global arbitration practice?
Yeah. Just taking the two specific developments you mentioned first. See, the notification is an own goal, right? I mean, it makes no sense at all. I don't even know where it came from. It's so badly drafted. It makes no sense at all. It's almost like some intern sitting in some department, came up with it, and they just decided to circulate it to everyone. Whatever limited conversations I've had around it, it seems that it will never come into effect. Even if it does, there'll be some sort of, there'll be litigation around it and stuff like that. So I'm hoping that those conversations I've had and whatever limited I've heard about it is true and that it would never come into effect. Obviously, it has huge ramifications. They're talking about a limit of 10 crores. That's $1.2 million, right? Most procurement contracts, procurement-defined broadly, would be much, much higher than that. The moment you say that those kinds of disputes have to go to litigation, and remember, our courts have no trials, right? We are purely a motion practice jurisdiction now in India, where only interlocutory applications, etc. move. If that's the scenario, then how do you convince any serious player to enter into a public procurement contract? It just doesn't happen, right? So, of course, that notification, I think, makes no sense, and I hope it will not go forward. The Delhi Metro case that you mentioned from the Supreme Court, of course, that's an unfortunate development. It's not necessarily unfortunate from the standpoint of it getting set aside. Any advanced jurisdiction should have checks and balances. And it's not the case that every award which is rendered should therefore always be allowed to go towards execution. Bad awards should be set aside. And maybe this was a bad award. I know nothing about it from that standpoint. I wasn't involved in it. The problem, of course, is that you get 3 bites at the cherry in the Supreme Court. And there's a perception created that because it was a large award against the government may have exerted some influence. Now, that's a bad perception to have. I know a lot of people were very worried about it. This Part 1, Part 2 justification makes no sense because, as you rightly said, that ultimately it's not about Part 1, Part 2. It's about whether or not you get multiple attempts, whether or not as a result of those multiple attempts, the amount of time you have to spend in the courts increases. And lastly, whether or not there's a proper rule of law in the country such that even if you win a large award against the government would not exert any influence on the judiciary to ensure that that award gets set aside. So I think, to my mind, Delhi Metro was a far more important development and a far more influential development in terms of what impact it might have on perceptions of the people, as opposed to the notification. Notification, in my view, is just rubbish. I mean, that document should just be sort of torn apart and thrown into the dustbin. It makes no sense at all. Now, but just coming back to the larger points that you said as to how we build India as a country which has sort of the right institutions in place so that it can attract the right kind of work and the right kind of talent. See, I've always thought that this needs to be divided in 2 parts. Yeah, any major hub of arbitration is a hub of arbitration, not just because it has the right arbitration act or it has the right institutional support. It also is a brilliant city to live in. People want to live in New York. People want to live in Geneva. People want to live in Singapore now. People want to live in Dubai or Hong Kong or whatever it might be. That's not true for India, right? I moved back, and I suspect that's the case for you guys as well, because somewhere deep inside, we're very patriotic about the country, right? So we want to live in this jurisdiction. But if you take out that aspect of it, would that many people from foreign jurisdictions who have no connection whatsoever to India just move to India because they find the right opportunities here? Would they ignore the fact that the air that we breathe is of bad quality. The water that we drink is of a bad quality, and so on and so forth. We might be able to overcome that because we have an emotional allegiance to the country. But why would someone else do it? So whenever we talk about this global hub, we should always keep in mind that the cities which are global hubs are not those hubs because arbitration infrastructure is great. It's because those are excellent cities that people around the world want to live in. Yeah. Therefore, the aspiration should be very different. The aspiration should be that this should be the right kind of setup or right kind of jurisdiction for at least doing international arbitration work and domestic arbitration work, which involves Indian practitioners. Yeah. Over time, we may be able to attract the international talent as well. But today, I don't think we are there. And we're not there, not because the Arbitration Act is not properly drafted, because no one wants to move to Delhi or
absolutely,
right?
Absolutely.
So I think that's the starting point. And whenever I hear people talk about global hubs and all that, I just laugh at it because it's just completely insane to talk about it in those terms, right? And compare yourself to Singapore or London because we're not there yet as cities. So the next question is, what more can we do? I think what's absolutely important is that courts stay out of it. It is happening, but it's not happening at the pace that it should happen. Second, former judges need to stay out of it. I think there should be a rule which stops former judges from sitting as arbitrators if possible.
I cannot agree with you enough on that.
Yeah. Third, we must have a system where institutional arbitration is either made mandatory as part of the law, or at least there's a real push towards it. There should be restrictions on who can call themselves an institution for administering arbitrations. I mean, if you look at any other advanced jurisdiction, there are only a couple of institutions that are there. In India, I don't know how many there are. Every second day, you hear some fresh institution popping up from somewhere.
And a lot of private institutions as well.
Correct. It's like the law schools in India, right? Like every
absolutely,
you pick up the newspaper and there's some new law school. The Bar Council or whosoever is administering them should control that. The same should apply to institutions. You get these things right, you keep the former judges out of it, you do some of these other things that we're saying, and I think you immediately see a huge improvement in quality. Yeah. And then we'll see what happens. But one thing which I feel is definitely not the solution, which most people tend to get very sort of excited about, is amendments to the Act. That's the last thing that matters.
I think it was last year sometime that the government opened up recommendations for to the amendments to the Act from everyone, and everybody enthusiastically, emailed their suggestions and recommendations to the government body, and I think nothing came about of it, to be very honestly. But what you meant,
But even if something comes,
I also remember. I also remember. I mean, I won't name the person, but a deputy registrar at one of the institutions had sent in a proposal and then posted it on LinkedIn, and the proposal effectively advocated for increased judicial interference in the arbitration process to make sure that the rule of law is upheld. And I was very surprised at reading that, because
it's counterproductive.
It's counterproductive at the end of the day. The intention is to minimize judicial interference.
No, it's counterproductive. But, the other thing which we often forget is that it's not about the statute. It's about the institutional infrastructure that you have.
Good.
I was reading this article in The Economist a couple of years ago, which had surveyed various Eastern European countries. And what they found was that a lot of the Eastern European countries who had poor governance went through the maximum amount of changes to their statutory regime. So what would typically happen is that a government, in order to show that there was activity and there were positive changes happening, keep amending statutes without putting in the budgetary allocation for improving the institutions. Whereas countries which are far better governed would leave their statutes the way they are and instead spend time, energy, and money into building institutions. India, we do the opposite, right? Take the example of the IBC. It's a brilliant statute. Of course, it was put together by experts who knew what they were doing. But what difference has it made? Nothing, because the government put no money into building the right institutions, right? You didn't put money into the IBBI, you didn't put money into the NCLT, you didn't put money into getting the right judges at the NCLT. So unless you build the institution around it, statutes won't make a difference. The English Arbitration Act hasn't been amended since 1996. Has it made England any less or more popular as a venue for arbitration? Not at all.
Absolutely. I think that's
you've got the right
good point. Yeah.
Yeah.
And that's a very good. I think one other thing that I personally feel is that we give litigants too many options to pursue at the same time. A person, for example, if there's a normal, simple check bounce case, a person can go under NI, a person can institute arbitration on that contract, a person can also go to IBC, under IBC to the NCLT at the same time. So this multiplicity of proceedings, I think, at the end of the day, the fact that our judicial system is so overburdened by these unnecessary litigations is also, I think, one reason that we have not been able to develop our legal regime in a more holistic, in a more advanced manner. For the simple reason that you keep bringing in statutes, you try to, the intention is always good, but the simple fact that, these small things will always be there, I think sort of pulls you back just a bit. And that's how I look at things. But yeah.
No, I think, Paras, you're absolutely right. Part of the problem in the Indian context, and now we're talking about litigation, of course, is that there are no checks and balances against frivolous litigation. Yeah. See, the biggest check against frivolous litigation in most jurisdictions, so if you take England, for example, is the cost regime, right? If you bring a frivolous suit, if you suffer an adverse judgment, you also pay the other side's costs. And not just nominal costs like the way we pay in India, 2 lakhs, 3 lakhs, actual costs. Absolutely. As part of the Commercial Courts Act, we did introduce the cost regime, but no one is executing it. Yeah. One single thing which I feel can significantly change the face of Indian court litigation, and particular commercial litigation, is if we introduce the cost regime in India and follow it meticulously, where each party is almost required as a matter of procedure and therefore follows it as a matter of practice, that they put in their cost schedules, not just some nominal number, but the actual time and cost that they have expended, what their clients have paid, including costs of their senior advocates. And if the party that has lost is required to pay that, and perhaps even deposit those monies in advance as part of security cost, etc., that would change everything. Because imagine now that you have to bring a proceeding and think not only that you have to pay your lawyer's cost, but you have to pay the other lawyer's cost as well. In India, doing litigation is very cheap, right? Because if you can afford your lawyer's cost, you don't have to worry about anything else. You don't have to worry about adverse cost. Court fees is very small. You don't have to really worry about the fact that there may be any penalties against you at the end of the process, even if there are appeal processes and so on and so forth. So doing litigation in India is very cheap and very easy in that sense. And which is one reason why there's so much of it.
That makes sense. And when you mentioned that, truly that, before we build any infrastructure legally and so on and so forth, the cities should be livable. And that's precisely why I live in Bangalore.
Well, there are people who would disagree with that. That I suspect it was very true earlier. I hear horror stories about Bangalore now, but I suspect it's still much better than some of the other cities in India.
Fairly.
Certainly better than Delhi.
It's come back to what it used to be. But then why? I think you also have your roots in New Delhi, but why Mumbai currently? Like, is there a particular reason?
Yeah, no real reason, to be honest. The personal reason was that when I was moving back to India, my wife and I both are from Delhi.
Okay.
Both have very large families in Delhi, so we wanted to be sort of in a city where we're slightly away from family. And Bombay made sense. Professionally, when I was coming back, I spoke to Shardul a little bit, and he said that, look, Delhi was the established office of SAM. it was quite crowded. Not crowded in the sense that too many lawyers, but already a well-established office with lots of litigators, etc. Bombay was their new office, very few lawyers at the time, and he felt that if I want to live if I'm okay with living in Bombay, then the Bombay office would afford me greater autonomy, which was absolutely correct. I mean, Bombay was just like an experiment at the time. And since then, we've loved living in Bombay. The city has been very good to us. It's a very safe city for women. That makes a huge difference for my wife. And, I mean, it's a very professional city as well. It has its problems, but I have never felt professionally at a disadvantage here, and culturally, I've found the city very easy. So now it just feels home. Delhi is still sort of my birthplace, but Bombay feels home.
Thank you so much, Rishab, for your time. I mean, this was a fascinating conversation. We didn't even have to touch upon any of the questions that we thought we would ask you. So many of them from investors, state, and so on and so forth. And none of that was touched upon, but yet it flowed so seamlessly, and it was fascinating to talk about.